I fell down the stairs at my apartment complex. The concrete stair broke due to the base being metal and it rusted away. I fell and tore my tendon in my left elbow. I injured my back as well, and I'm in a cast for 6 to 8 weeks. I am left-handed and this is screwing up my life. Do I have a good case? The insurance contacted me. Do I get an attorney? If I settle with insurance, how much? Thanks in advance, RG. A lot of questions there, Les.
A lot
what
of
do you
questions
think?
there. Well, the first question that needs to be answered is absolutely you need to get an attorney.
Right.
You know, dealing with insurance companies, it can be a very tricky thing. They know the law, they know the claims process, and most people, unless you practice the type of law that Ted and I do, they don't really understand the process that you have to go through in order to prove up your case, provide the evidence
right.
that is needed in order to justify them paying out a claim. So question number one, do I need an attorney? Absolutely. As far as do you have a case, I mean, it sounds like they do. I mean,
right. I mean, as we've said many times on this show, just because an accident happens on the property it's not a strict liability case. An owner is not considered an insurer of the whole premises. There has to be some sort of fault. And the first thing I hear and key on in this particular fact pattern is they say it was rusty.
Yes.
And what does that indicate? This is something that happened over time. And so that is a piece of evidence that you can utilize to establish that either the owner knew about it or should have known about it, because this is a condition that's existed for a long enough time that it's now rusted through and it's fallen and it's caused you an injury. So absolutely that's something that is worthwhile to pursue. And as Les mentioned, you know, the insurance companies have professionals working from them from the word go. Do not try to go it alone. This is something you need help with, and you know, all cases need help and all cases need professional assistance, but a premises liability case is a tough one. Juries can be naturally suspect of trip and falls, and especially slip and falls, because everybody thinks of folks going in and faking an injury or doing something, you know, that happens sometimes. Yes, it's the exception, not the rule. But you want to make sure and document everything and have it done properly, because once you get on the bad path, it can be corrected, but it can be difficult. Yeah,
absolutely. We know in this particular case with the concrete stairs and the frame that's been rusted out, like Ted said, I mean, that's obviously something that's happened over time. You know, landowners, while you're not going to be automatically liable in the event somebody falls or injures themselves on your property, you still have certain duties and responsibilities. Now, in the case of the apartment complex, they have an obligation to inspect their premises to make sure everything's in working order, whether it be the steps, whether it be elevators, if they have elevators on the premises. You know, if they've got a pool deck, is the pool deck unreasonably slippery? Have they treated it in such a way to where it's becoming a slipping hazard? So they have these obligations in order to make the property safe. And if they can't make it safe or there's some hazard, they have an obligation to warn you of it. But in this particular case, this is the worst kind, because it's a hidden hazard.
Right, because that's hidden is a key word there, because you know a landowner there's exceptions for being liable if it's something that's considered, the law says, open and obvious. Right. So if there's a hole sitting right in front of you and you see it, you can't walk into the hat and then say, "Oh, you should have fixed this."
Right. I mean, well, you can. You just won't.
You won't have a good.
Yeah,
right. As I tell my mother-in-law all the time, you can file a suit over anything.
That's right.
The better question is whether or not you're going to be successful with it. So, you know, the problem here is, and in addition, when you're dealing with an apartment complex, this may not hit that area particularly, but you can deal with some additional statutory obligations with respect to providing a habitable home and things of that nature under Chapter 83 of the Florida statute. So definitely something needs to be pursued, and make sure you reach out to somebody, RJ, so you can get that taken care of.
Yeah, absolutely.
You know, a question that I see and arise from times is, you know, obviously an apartment complex, you're thinking of a commercial property, a business type. But you know, less of the same rules apply if you're on a private landowner. If I'm at your house, for example, and you have something that's wrong, do the same standards and rules apply?
Yeah, I mean, whether it's a commercial property or whether it's a private residence or private property, you still have those obligations as a landowner to make sure that you don't have any unreasonably dangerous conditions lying around. And if you do, or if you have something that could be hazardous, you have to provide a warning.
Right.
Now, you know, obviously in your case, you would be a guest in my house, and so you would have the highest level of protection being somebody that I've invited onto my property. sometimes we get the call somebody's actually trespassed,
Right.
and they get hurt, and then they want to sue the landowner or the property owner, and they were a trespasser. Well, guess what? You don't have the same protections as a trespasser because you weren't supposed to be there in the first place. So think about it from this standpoint. If you own a home and you have somebody coming in, let's say to provide a service, a plumber, an electrician. We've had cases where service providers have come into homes and things have happened. They've either fallen, they've tripped, they got bit by a dog. You are liable for those situations if there was a dangerous condition and you didn't address it. So, yeah, I mean, the law is really, it's pretty even across the board there.
Right, and another aspect of a homeowner's policy, typically that's going to fall under your coverage for that will be under your own personal homeowner's policy. And so even if there's another level of coverage on those policies that even if there is no fault, let's say you just you fall out of the chair because you're uncoordinated or something of that nature. On your homeowner's policy, there may be and should be a coverage called medical payments coverage that will pay simply because you were on the property and had an accident. It's essentially health insurance built into that policy. So if someone comes on your property and is injured, even if it wasn't your fault, you need to put your homeowner's insurance carrier on notice out of an abundance of caution. That's one of your obligations under your insurance policy. If there's an accident, let them know so that you don't prejudice them in any investigation they need to do, and so that you have all of the coverages that you've paid for at your disposal if something were to arise.
That's right. And that MedPay coverage is usually, rarely is it going to be of a limit that's going to provide a significant
Full
amount
value,
of coverage.
right.
You're usually talking anywhere from $1,000 to $5,000, which sounds like a lot of money until you make a visit to one of the local ERs and have a couple CT scans done, and then you realize that $5,000 really doesn't go as far as you thought it would.
It could help with somebody with co-pays or such if they have their own health insurance. So that's just something to think about, something to keep on your mind if and when it ever happens.